Mediation is a formal meeting between the parties involved in your lawsuit. It is an attempt to settle your case before it goes to trial with a judge or jury. There are many benefits to settling the case rather than going to trial. Here are a few. Resolving the case now versus drawing it out with a trial. Having the use of money now versus having to wait. You have control over how much money you are willing to accept to settle your case. In trial, it is up to the judge or jury to decide the amount of compensation that you will receive. You will be certain of having made a recovery, while at trial there is a possibility of a verdict in favor of the defense. By settling, you will avoid additional costs that are affiliated with going to trial, such as paying your doctor for his or her time for testifying on your behalf. You will avoid the stress, hassle, and embarrassment of a long, drawn-out public legal proceeding. Make an appointment before the mediation to discuss with your attorney the monetary benefits of settling your case at mediation compared with going to trial. Your attorney will also give you a realistic idea of what the value of your case is. Listen to your attorney. The following people will most likely be present at your mediation: yourself, the plaintiff, your attorney, the defense attorney, a representative from the defendant's insurance carrier, and the mediator. More likely than not, the defendant will not be present. Instead, the defense attorney and the insurance adjuster will be at the mediation on the defendant's behalf. During mediation, the mediator will assist both sides in the negotiation process. Mediation gives the defendant's insurance carrier the opportunity to make the best offer that it is ever going to make to settle your case. You want to see what that offer is. Then you can decide whether you should settle your case or go to trial. The goal of mediation is settlement, which will avoid an expensive trial. Oftentimes, for mediation to be successful, all parties will reach an agreement only if they are prepared to compromise. Your appearance can affect how the opposing side evaluates the case. You should dress much like you would for a special occasion, such as a job interview. Women may wear a skirt and blouse or dress slacks and a blouse. Men should wear nice slacks and a collared shirt tucked in with a belt. Do not wear jeans, shorts, or a t-shirt. Women should avoid wearing too much makeup. Hair should be brushed and appear well-groomed. Your clothes should cover tattoos and body piercings. Jewelry should be minimal and facial jewelry removed. Mediations vary in length, but usually last at least a few hours. Your attorney can usually advise you if the mediation will last longer, so you can make arrangements with work or for childcare. There are 2 sessions to mediation: the initial joint session and the individual sessions. The first is the initial joint session. Everyone involved in the mediation meets in one room. The mediator will go over the mediation process. Some of what the mediator says may be repetitive of what your attorney told you, but listen carefully. There will be new information. Both attorneys will have a chance to summarize their side of the case. You should listen carefully to the opposing attorney's summary. This is a preview of what the defense will tell the judge or a jury should your case go to trial. You will need to compare the strengths and weaknesses of your case to the strengths and weaknesses of the defendant's case. This comparison will help you decide whether the case should be settled or tried, and will help you calculate a reasonable amount for settlement. As the defense attorney gives his view of the facts of the case, he may focus his attention on you. You should not respond verbally or through body language to what is being said. There will be a time when your side of the story is told. You should not say anything throughout the initial joint session unless your attorney asks you to do so. After the initial joint session has ended, the individual sessions begin. Each side will go to separate rooms. The defense attorney and insurance adjuster will be in one room, and you and your attorney will be in another. It is at this time you, your attorney, and the mediator discuss the strengths and weaknesses of your case compared to the defense in order to calculate an appropriate settlement amount. Whatever is discussed with the mediator is confidential and will not be repeated to the defense unless the mediator is authorized to do so. The mediator will then move back and forth to each room, helping each side rethink its case in an attempt to come up with an agreed settlement amount. Don't worry if it seems like the mediator is spending more time with the defense. The mediator does not make decisions that influence the outcome of the case, meaning the mediator does not act like a judge or jury by ruling in favor of the plaintiff or the defendant or determining the amount to be paid. Unlike in trial, the decision to settle the case is in your hands, and any final decision is yours. There is no amount of money that can wholly make up for what you have been through. However, you're entitled to compensation for your injuries and damages, such as medical expenses, lost income, and pain and suffering. Pain and suffering is determined by the nature, extent, and permanency of your injuries, what type of treatment you have undergone, and what effect your injury has had on your ability to work and engage in normal, everyday activities. Your attorney will better provide you with an exact list of what items are recoverable, depending on the details of your specific loss. Be sure to talk this over with your attorney prior to mediation. Settlement offers and demands between you and the defense will be exchanged through the mediator. This part of the mediation may feel very impersonal because the issue of money will be the main topic of discussion. Everyone is aware that this case is very personal to you, but monetary compensation is all that our system provides for. More likely than not, you will not agree with the first few offers that are made by the defense. Likewise, the defense attorney and the insurance adjuster may not like your first demand either. Even though what you say to the mediator is confidential, you should not tell the mediator what amount of money you would be willing to settle for until otherwise instructed by your attorney. You may have to settle for less than what you initially thought you would settle for, and the defense and insurance adjuster may have to pay you more than what they were planning on in order to settle. Your goal as the person who is making the claim is to persuade the insurance company to make the highest offer that they are going to make so you can decide whether to settle. When talking about settlement offers and demands, those amounts are the gross settlement figures. These are not the dollar amounts you will have in your pocket if a settlement is reached. Let's use the gross settlement amount of $75,000 as an example. These numbers do not reflect the dollar amounts in your case. They are examples only. There will be certain deductions from the total settlement figure. Your attorney or the mediator will explain to you each of these deductions in detail according to your particular case. For example, there will be an attorney fee. In this example, the attorney fee is 40% of the gross settlement amount. Expenses advanced by your attorney on your case, outstanding medical bills, and subrogation liens, which are amounts of money, if any, that must be repaid to various medical carriers for medical bills and/or lost wages, which they have paid to you on your behalf. As you can see in this example, out of a $75,000 settlement, the plaintiff would receive $37,000. Let's take a look at a jury verdict of the same amount. The jury awards you the same as the settlement amount, $75,000. Your attorney fee might go up if the case goes to trial. The total expenses paid out by your attorney to try the case will increase, sometimes substantially. For example, you will have to pay your doctor for his or her time to come to court or to give a deposition that can be presented to the jury at trial. Your medical bills may increase. And the subrogation liens as described earlier. In this example, after subtracting all of the expenses from the jury verdict of $75,000, you would be left with less money than you would have received by settling out of court. As you see, going to trial does not always add up in your favor. It could take a $98,000 verdict to receive the same amount of money that you could have had with a $75,000 settlement, not to mention all the extra time and money that you can never get back that was spent on trying the case. This assumes that the jury would come back with a plaintiff verdict. In truth, there is no guarantee that a jury will find in your favor at all. Each case must be evaluated independently with regards to the liability facts and the damages incurred. Remember, this was just an example. You will need to discuss with your attorney what deductions are appropriate for your case. The mediation is the best opportunity to maximize the value of your case. At the end of mediation, it is up to you to decide whether to accept the final offer or to go to trial. Typically, your decision will be made before you leave the mediation process. Let's review the rules that will help your mediation go smoothly. Be prepared to compromise. Dress as you would for a special occasion, such as a job interview, but don't overdo it. Make proper arrangements for time away from work and for childcare. Listen carefully. Do not react to the defense's presentation. During the joint session, don't say anything unless instructed to do so by your attorney. The ultimate decision, whether to accept the final offer or go to trial, is up to you. The goal of your mediation is to get the highest offer, then decide. And you may end up with a greater recovery by settling the case than risking an uncertain and expensive verdict. Mediation gives you the opportunity to make a fully informed decision about whether to settle your case or not. If you decide not to settle, then you have a right to go to trial. Remember, mediation is a negotiation process. Even though you may not get the full amount you want, the defense may pay out a lot more than they planned. Avoiding the expenses, risks, and problems of a trial are often well worth the compromise.